Hi from my platform, Linda's TV show. If it is your first time, you are welcome. Please, after watching this video, if you like what I'm doing, please subscribe, put on your notification bell to all notification. It is very, very important because it will enable you to know when I upload a new video. Here we upload videos on daily basis as it is happening. We are bringing it live and direct, undirected to you. After watching, you are free to criticize, you are free to say your opinion, but let us say it constructively. Myself, Linda, will be standing here watching this video together with you from the beginning to the end. Then we'll go to the comment section. I appreciate you all, my lovely subscribers, followers, those who comment and share this video.
Thank you so much for joining us this afternoon on Newsday. How feasible would it be for the courts to resolve all these litigations before inauguration? Because as we've seen, there's been a bit of tension when these CTCs are being filed, as we saw in River State yesterday with the candidate of the APC being slapped and having water thrown on him, all those sorts of skirmishes when the entrance was blocked towards the INEC office when they were trying to get their CTC. So in your opinion, is this something that's feasible to be done before the 29th swearing in?
Yes, to be honest with you, the law is very clear as to how many days will lapse between presentation of petitions, the hearing of petitions, and the determination of petitions. And I don't see anything wrong in that period. The period is for 180 days, and I believe that if there is sincerity amongst Nigerians, the period is okay, and things should have been done. But you know, in everything in Nigeria today, the Nigerian factor is always there. And the Nigerian factors, you and I, we Nigerians, we are the cause of all our problems. So if we are not Nigerians, whom we are, and we decide to do things in the normal way, 180 days is enough, and we have enough time to ourselves.
Well, but some people are saying, that considering the fact that the election was quite controversial, that nobody should be sworn in under such circumstances. We've seen cases in other African countries, for instance, Kenya, where election disputes are fast-tracked, and that is usually done before the swearing-in ceremony. So some people are saying that that might help douse the tension here in Nigeria. I don't know what your view is on that. Should there actually be a swearing-in before the election dispute is resolved? And then also, I'd like to know your position on calls for the Presidential Election Tribunal proceedings to be televised live. What's your take on that?
Could you speak up loudly a bit? I can't hear your two questions very well.
Okay, I talked about the fact that in some other African countries, Kenya, for instance, they were able to resolve their election dispute before the swearing-in ceremony. So some people are saying we should take a cue from that if an election is controversial, the controversial winner, so to speak, shouldn't be sworn in under such circumstances, that issues surrounding the election should be resolved before the swearing-in. What's your take on that?
Well, let me be honest with you. The Nigerian factor is not only the law, it is also the people. In other African countries, we do have skirmishes. Skirmishes are still going on in Kenya today, as I'm talking. Yesterday night I saw on television, we saw skirmishes. But let us look at one thing clear and clear. The Nigerian constitution is the failure Nigeria has had for the past 23 years. This constitution that allows election to start and restricts an individual from being part of the election except he becomes a member of a political party is no good for this country. Whereas the law says every Nigerian has equal right to a vote, and that every vote of a Nigerian counts. However, the same constitution now says that to be able to present yourself as a candidate at an election, you must belong to a political party. Therefore, if you are not a member of a political party, you cannot contest an election. You can see the enormous power the Constitution has given to a political party, and that is the bane of the problem we have today. You now find that any Nigerian who takes over a political party automatically takes control of governance. That is the number one principle. And now you find this do or die. Do or die becomes part of Nigerian system because the Constitution allows you and I, who have been voted into power, to steal as much as we want, to do as much as we want, and no consequences arise. Therefore, every Nigerian wants power to be able to, take over power and deal with all enormous powers surrounding him. And, of course, the do or die principle comes in. Therefore, one has to look at the Constitution and see what we can do so that the element of this do and die one, the element of restriction of individuals into the governance of the country, and the tolerance of the people in relation to religion, in relation to ethnicity, are eroded from our, way of life. Until we remove these three things, we can never have it right in Nigeria. When we've had about 7 elections and none has been credible, let's be honest. If we have 5 more elections in 15 years' time, we will never make it. Because the element of being a Nigerian, the element of fighting do or die and taking over control of power, if not removed, we will, still get the same result. There will be confusion, there will be chaos.
Well, as a senior advocate of Nigeria, I wanted to get your opinion on assessing the grounds under which both parties are taking their cases to the court. And I mean the Labour Party and the PDP to make their individual cases in court. We do know that the law is placing the burden of responsibility on the respondent to prove electoral misconduct in that every single vote that they received was indeed true. How would you assess these grounds that they are taking to court? Is it going to be easy to prove, or is this going to be an uphill battle?
Well, let me be honest. I can be proud to say that in Nigeria today, I am one of the few lawyers who have been involved in political chickism in Nigeria from 1974. I was Shagari's lawyer, I was NPN's lawyer in 74. I was sole counsel to NRC in 1991. And I have been involved in politics here since 1999. Let me be honest with you. Let me analyze. Let me take, for instance, the the Labour Party. They have filed an election petition based on one, that Bola Tinubu is not eligible to be voted for. 2, that even if he's eligible to be voted for, he did not get the 2/3 in Abuja State. And that even if he got it, the elections was marred with, gangsterism and different things. Those are the 3 elements that the Labour Party has brought forward to an election petition. Now, let me draw on the pool of my own experience. The first one is that he was not eligible because he has been found guilty, but that is a non-starter. That issue has been settled and is a non-starter. So the Labour Party can never make any headway on that ground. The second ground is that by virtue of the Constitution that says to win an election, despite and in spite that you have made the greatest number of votes, you cannot be declared elected if you did not have 2/3 in 36 states and Abuja. The question to be considered by the tribunal is, what constitutes 2/3 of the 36 states in Nigeria and Abuja. And how do you construct that word? And do you take 36 states first, and you now take Abuja, and now say that for you to be elected, you must have 2/3 of 36 states and 2/3 of the federal capital? And that is the view of the Labour Party, which I do not agree with. Now, look at this, the scenario they are saying. If Tinubu had won 2/3 of all the 36 states and fails to win 2/3 of Abuja, then he cannot be elected. Does that make a sense? Does that give any good reason for democracy to survive? No. Now, we lawyers, we have what we call, in looking at whatever construction is, we look at the mischief. What does the National Assembly want to cure by that? When they said you must have 2/3. Now the Supreme Court now says that, look, Abuja has been created as one of the 36 states, so it enjoys the status of a state. But the Supreme Court in one or two other cases also said, in determining whether Abuja is a state, you should not grant Abuja any privileges. Once you declare it as a state, it enjoys the same status as a state. The Constitution itself says all votes cast in an election in Nigeria are all equal. So having had these three principles, that Abuja cannot have any special status, that all votes cast in Nigeria have equal status, then why do you want to interpret "and" there to mean that if even I have 36 states, 2/3, and I don't get Abuja, then I cannot be elected? It doesn't make sense. Democracy means plurality of the people, for the people, and for the, all the people. Therefore, my own view, which I think is a reasonable view, but I'm subject to, other views by my learned and by the Supreme Court, is that in determining whether Tinubu has made that provision of 2/3 of the states, it must be the 36 states plus Abuja, which is 37 states. So if he has made the plurality of 2/3 votes in all these states added together, then he becomes elected. But as I said, this is subject to interpretation by the Supreme Court. But I am basing my submission on what the Supreme Court has said on Abuja, what it has said about votes, what it has said about equality of votes amongst the states. And I am subject to being, my opinion being rejected. But that is my view. Thirdly, the other step, even if the Labour Party decides that Tinubu has not qualified by virtue of past precedents, if they claim he did not have, and the court says it has, they still have to surmount that principle that the elections were marred with many, many irregularities. Now, what does the law say? The law says there is a presumption of regularity attached to whatever INEC does. The Evidence Act in Nigeria gives INEC that privilege. Now, the election petition is based on the principle of sui juris, which means that compliance with the provisions of the Electoral Act is not a total compliance, but must be complied with substantially. How do you decide that word, substantiability? The Supreme Court now is in that difficult position to look at all the evidence to be brought by the Labour Party regarding malpractices. Now, the notorious place Labour Party is holding is Lagos State. They are claiming that in Lagos they were cheated, the voters were not allowed to vote, there was this, okay. When they prove it, they still have to go a step outside the proving to show how it has affected the election. I was listening to one or two commentators who said, look, of all the number of wards in Lagos State, thousands of wards, Only in about 84 words could the Labour Party says there were malpractices. Now the question, if they are able to prove that there were actually malpractices in those 84 words, how has the result in those areas affected the election? So they have an uphill task. So my own view, from my own experience in election matters, it is an uphill task for them. But you never know. You never know the circumstances of these malpractices. You never know how many votes were not allowed to be cast. So I cannot pitch my tent to say that they will not succeed. But my belief is that they have an uphill task. Very, very steep uphill task. Thank you.
And on that note, Senior Advocate of Nigeria.
Thank you so much, my wonderful viewers, for watching this video together with me from the beginning to the end. Like I said before, if you like what you see here, if you like what I do in this platform, as you have finished watching this video, please hit that red button that says subscribe and put on your notification bell to all notification. In that way, you'll be able to know when I upload a new video. Share my videos, leave your comments in the comment section constructively. Until I meet your way again in my next video, I still remain your Linda's TV show. Bye-bye.